Hello, good evening. I'm Dr. Ravi Kolli, your president of AAPI, truly yours. And we're here again today to discuss more interesting aspects of financial planning. With us today is Syed Nishat. I'm going to explain a little bit about him later. The event is hosted by AAPI, and I'm the host today. And as you know, this is educational webinars. So the disclaimer is that you need to consult with your own personal financial planners and tax consultants and tax lawyers for any kinds of estate planning and wills and all that. So beyond that disclaimer, let's get started. As you all know, we physicians are a vulnerable group of people dealing with life and death on a daily basis, seeing patients, and also we're at risk for contracting illnesses, which has tremendously affected us during this COVID. As we all know, we lived through phase of fear and panic, going to work and coming back to work from home from work, and we are exposing ourselves to COVID on a daily basis. And as you know, tragically, one of our good friend, Dr. Ajay Lodha, past president, passed away from COVID, and some of other members of AAPI have survived. But that has brought to the attention of all of our psyche how vulnerable we are. And we like to not to think about mortality and death, but now the pandemic has opened our eyes to be more cognizant about our vulnerabilities and our fragilities. So estate planning is very important on that basis. And the rules change for every year for this estate planning. So the information needs to be current, and it can be overwhelming for us physicians. So we need an expert like Syed Nishat to explain to us what are the upcoming changes and upcoming rules that can affect you negatively if you make a small mistake or small miscalculation on how you do your planning. So let's, without further ado, let me introduce, we have Syed Nishat. Syed is a fiduciary, which is an important distinguished feature for a financial advisor. He's a partner at the Wall Street Alliance. Syed has written many articles and interviewed for many media outlets, including MedPage Today, Medscape, as well as Forbes, Kevin MD, US News, Investment News, Yahoo News, etc. And he also has written and given interviews about asset protection and common financial mistakes we all make. So let's talk about it. And we'd like to make it an interactive seminar and a webinar. So it won't be a long, boring presentation. We'll have some questions and answers. And I'll ask the questions and Syed will answer. And then you can also ask your questions through the chat box. And then we'll also answer questions later. We cannot get to all of them through email responses. Okay, let's go, Syed. Let's get started. Thank you, Syed, for coming again and helping us with the asset protection and estate planning.
Thank you, Dr. Kolli, to invite again. Appreciate it.
Right. Let me get into the question and answer phase right away, because we have a limited time and a lot of questions. First, can you explain what does it mean when we speak about estate planning?
Yeah, so thank you very much again, Dr. Kolli, to invite me to this webinar. So estate planning is one of the most important but most neglected aspect of financial planning. Whenever I've been doing this financial planning for almost about 17 years, every other physician prospect I speak to, one thing they're lacking, they just say, hey, I just got the basic will done, no estate planning done. And most of the time, I think the reason why they don't do this estate planning because it is complicated. Every time they talk to the attorney, they actually send them a bill. So what this time you and I, we decided to do, hey, let me just give all that information possible, the basic, what needs to be done. So in this way, they can be prepared about the basic estate planning done. Now, the first question is, what estate planning means and what do I have to worry about? People ask about estate planning. Estate planning means if anything happens to you and your wife together, only it comes into play. Understand one thing, that husband passed away, everything goes to the wife, stay tax-free, vice versa. Only both pass away, then we have to worry about it. So first components of estate planning is like if anything happens to one of you, you need to have a will. Will means what will happen to a portion of your property if anything happens to you, and who will take care of your children, and what will be the division of your assets after both of you passed away or one of you passed away. That's basically what it wills. A simple document. It is public. We do not call it a private document because what happened that once you create a will, you need to notarize it, the will, and you keep it to yourself. It comes into play when one of you passed away, and if you have a separate will, that will needs to be sent to the court. Now, when you send to the court, it could be up for probate or debate. That's why basically we call it, it's not a private document. It actually involves a little bit of a probate. The court has to authenticate the will and then release the funds. So that's why will basically sometimes goes into probate. So you need to have a will that basically outline your wishes, what will happen to you if you pass away. Now, while you're alive and you are sick, there are two things to come into play. One is called health proxy, one is called power of attorney. These two are important. One of my best clients in Texas, Dr. Kolli, passed away during COVID. I cannot imagine this client not having a will and trust, and there's no way to measure his loss, but having a proper estate planning done actually allowed the family to focus on his health and not focus on other things. And this wife of my clients actually held power of attorney because the husband was unable to talk at that time because of the tube they put in. The business was running. So you need to have a power of attorney. The wife or husband, vice versa, they can make a decision if one of them incapable of making a business decision. That's called power of attorney. That is there while you're alive, but the other person cannot make a decision. You need to have a health proxy as well. As a physician, health proxy is basically plug in, plug out decision. This is when you're actually very sick, someone is to make your health decision, you need to have the health proxy as well. This thing called living will, while you're alive, only works into play. When you pass away, the power of attorney does not work. The health proxy obviously does not work. At that time, the will kicks into play, and then you use the will and basically divide the property according to the wishes. Now, as I mentioned, will does not avoid the probate. Depending on the state you live in, probate is getting easier just to be open up. Like, for example, New York, New Jersey, slowly it is getting open. But if your assets are complicated, Dr. Kohli, think logically. If your child, let's say my son, Noah, he's 1 year old. If me and my wife both pass away, Noah cannot go to court, right? And 1 year old and get the assets. No one will come to my son and give the property, right? Someone is to send it to the court. Court then release the money, my assets to my son, create at that time some sort of account and then transfer all the money and then give it to my son according to my wishes. This time is called probate. It is not instantaneous. Sometimes it takes 3 months. It is getting better, but sometimes depending if you live at the south, it takes more time, up to 9 months, depending on what state you live in. So that's why we also recommend for physician, if your net worth is substantial enough, and if you have multiple real estate, which is quite common for physician, get a trust as well. So there are two types of trust. One is a revocable trust, irrevocable trust, we'll talk later, but we recommend to create a revocable trust. The trust, Dr. Kohli, is a private document, unlike will. You need to have a will, you need to have a trust as well. Trust, basically what happened, you create it, and you make a trustee as well while you're alive. And you move all the assets under the name of the trust. Like, for example, house will be needs to be moved under the name of the trust. The retirement account beneficiary needs to be secondary to trust. Brokerage account will be under the name of the trust. So if anything happens to husband and wife together, nothing goes to court. All already are private, all funded. So in this way, there's no probate. So just to summarize, you need to have a will, you need to have a living will, which is called health proxy power of attorney. And we also recommend creating revocable trust for physician if your net worth is substantial enough or multiple properties, and funded as well. These are basically the main components of estate planning when we talk about basic estate planning.
Okay, excellent kind of description, even for a layman like me can understand. So will is a private document. It can go into probate. It's not a public, public document, not a private document. Whereas a trust is a private document that can be, trustee will take care of it. It can be a living trust or a revocable trust or a irrevocable trust, right? And then
Yes.
let's get into the, what age should we start thinking about these wills and trusts and all those things? Because we have young physicians, we have residents in training, we have a seasoned physician, senior physician. When is it too late and when it is too early to think about this wills and trusts?
Right. So basically, it doesn't really matter your age. Remember, a lot of physician comes to me. I am 45. Like I am 40. I turned 43 today, so I'm 43. So people say I'm going to be 60. I'm going to do my will and trust. No, no, age doesn't matter. What matters is how is your net worth. That it matters. All right. If you have children, that it matters. If you're a complete single person, you don't care about anything, that's a separate story. But age doesn't matter. What matters if you have a family, if you have young children, if you have some assets, that's the most important thing. So at least we recommend get the basic well done, regardless of your age, as long as you have some net worth done.
Okay, that's very important question. Sometimes we think wills and trusts are for old people. So if you have a lot of money, it's better to have a trust. And if you have children, it's better to have a will and all those things. Thank you.
Yep.
So when you speak about the trust, what is the difference between revocable and irrevocable? That you mentioned a little bit now, explain a little bit more. And if you have a trust, do you still need a will also?
Yeah. So remember, there are two types of trust I mentioned. One is a revocable trust. One is an irrevocable trust. Revocable trust means you can change it anytime. Irrevocable trust means once you create it, you cannot change it. It's very hard to change it. That's why it's called irreversible or irrevocable. We always recommend creating a revocable trust for a basic estate planning purpose. Irrevocable, you do it for gifting purpose. Let me make it very simple. If you want to gift it out of your state, that's irrevocable. If you want asset protection, irrevocable. I would say 50% of our physician clients, they go for revocable trust who are young, don't have too much of an asset, just want to create a probate, avoid probate, go for revocable trust. Now, understand one thing, that once you create a revocable trust, one of the spouse pass away, that portion of the trust becomes irrevocable automatically by state law. So, and the benefit is that the children inherit the money from your revocable trust, which is now irrevocable because you pass away. The law, state law says is irrevocable and no one can change it. The tomorrow children actually get into a lawsuit or divorce, they get married, all assets are protected. Again, nothing to really worry about. And number two, I know I'm getting a little technical. If you give the money to a trust, let's say, for example, you bought Apple shares at $100, stock right now is $150, and you own it through revocable trust, you pass away, your children own it at 150, their new cost is 150, not 100. So it gives up something called step up in cost basis. So I know it's a little technical, but in a tax point of view, it also helpful as well. So to answer the question, very simple. You basically need to have a revocable trust, not really irrevocable trust, unless like your net worth is substantial enough that you want to gift it.
All right. So you're giving a gift to a child or somebody, it's better to be irrevocable so that they won't get it until it's
Exactly.
waited. Okay, very good. Very good. So what are the common mistakes we physicians make when we create a will or a trust, besides not creating one at all?
Right. So when we do the drafting, when you go to the attorney, just a few mistakes we see all the time. Like, for example, I have two of my kids. To give you a personal example, I have one son who's 4 years, one son is 1 year. Like, if I pass away, husband, wife, both together, I don't want to like give directly under the name of my son. Noah or Ayan. These are my two kids. I have it because think logically. At one point, the kids will become older and they get into a marriage. And if they get into divorce at that time, the asset becomes half if I give him directly under their name. So the way to give it is make sure that you put a clause in the revocable trust. If anything happens to both of you, husband, wife, the children must create their own trust and transfer the money. They never commingle in this way with their spouse. So in this way, all the assets are protected. Number one, mistakes we see it all the time. Number two, we see that people create all this excellent fancy trust, but they never fund it. What I mean by funding, you have to move it though, by the way. If you have a house, move it under the name of the trust. If you have a brokerage account, move it. If you don't move it, you created paperwork, no value. So again, you have to fund it as well. And number three, not updating it. What I mean by that, like we had a client from East Coast to move to South now, a lot of retirees. By the way, you created your trust. I'm just giving an example, New York, now in Florida. Florida has their own statute. You have to update the trust. Or just in case if you got divorced, don't have your ex-wife or ex-husband get all the assets, right? You have to update it, all of it. So make sure you update the latest provisions as well. So these are the three common mistakes we see in estate planning.
Very good. So updating it, funding it, transferring it, and all those are very important.
Yes.
So I think next question kind of addresses some of the what you already asked answered. So if you have created a trust, how does the titling of the assets work? You mentioned about funding the is it the same as titling the trust?
Yes. So it's not that complicated. Like, what happened, the house you have it is remember, revocable trust doesn't have any tax ID. It's under your social security. All right. You create it. So if you have a bank account, you go to the bank, and as long as you have a savings account, you don't touch it too much long term. You just tell them, I want to create like a revocable trust, please, and move all the funds. If you have a house, the lawyer usually take the deed of the house and change it and send it to the county as a small fee, and the house are titled under the name of the trust. So make sure you fund it as well. It's not that complicated unless you have a lot of LLCs, real estate, but funding is also important.
Okay, very good. I think one of the question on the question answer box is also the same thing. Some of our physicians are non-citizens. Do they have to worry about any special provisions for estate planning? I think
Yeah.
a question by Dr. Praveen Maheshwari. Does one need to be a U.S. citizen or a permanent resident or okay?
Yeah, you can do it. You can create will and trust, no problem. But one thing to understand, and this is a lengthy conversation, obviously we have to talk more, but I'm just giving you a glimpse of it, okay? So between husband and wife, if me and my wife, we are both US citizens, we passed away, between us is unlimited transfer. No, there's no gift. I can give like unlimited to my wife. My wife passed away, unlimited to me. But that's not the same case for non-US citizen. The amount is very small though, and the amount keep changing. So if non-US citizen spouse passed away, give it to a spouse who was non-US citizen, there are some taxes due, but there are ways to fix it. And the solution is, again, we're not going to go too detail. When you create the trust, speak to the attorney to put a provision called Q dot, qualified domestic, Q dot protect, provisions there in the trust. In this way, this issue can be avoided. But again, there's more discussion into it. Like for example, domicile versus non-domicile. What if the wife becomes citizen after you create the will and trust? How to fix it? More discussion needed, but it is not as straightforward. The provision should be discussed with the attorney as well. A lot of time people don't say that I'm not a US citizen whatsoever. Some provisions needs to be there.
Okay. So if anyone has a child with special needs, that's also very important these days because of all the cost of taking care of a special needs child is ballooning. So how do we deal with that aspect in our creating trusts and wills and plans and all those things?
Yeah. So again, this is another one of the criteria. So the whole idea, Dr. Kolli, what we're trying to do is give the ideas. The solution, remember, they have to speak with their attorney, right? It's because they don't know about all of this. So we spoke about U citizen, non-U citizen, but sometimes a lot of people do not know that, by the way, I have a child with special need. They just created like a revocable trust without really discussing with the attorney. Understand, in America, if any assets more than $2,000 under the child with a special need, all the benefit goes away. Like the government benefit goes away. Like for example, if they have a therapy is getting provided, SSDI, the child is getting it, depending on what the child situation, all goes away if more than $2,000. But you can avoid it by creating something called a special need trust. Could be revocable, irrevocable for the benefit of the child with special need. So the benefit is that that all the money goes to the special need trust. The government benefits remains entail. And then if you're collecting SSDI for the child, a certain monthly benefit that remains there. And also you can open an ABLE account as well, like similar to 5 to 9 accounts every year. So again, we are talking about a glimpse of it. Just in case, if you have a child with special needs, speak to the attorney about special need trust as well.
That makes sense because a lot of my patients who I'm a psychiatrist who have some disabilities, they have they're always told to have spend down. If you have assets, you cannot get benefits, you cannot
Yeah.
use them. So it's very important to separate those two so they don't lose the benefit that they need. Thank you. So how often should we update these wills and trust documents?
Right. Usually, a will and trust are good for 7 to 10 years. Usually, unless like your circumstances changes, like as I mentioned, if you're moving to different states, if you have children who are grown up right now, you want to make them a trustee, change a trustee. So changing a trustee, I'm saying that these are, once you create like a big trust, changing trustee is very easy. But I'm saying that every 5, 7, or 10 years, we see the laws keep changing for the state purposes. So you have to just have the statutes. Sometimes I see that the trust has been created like 15 years ago, the statutes has been changed. Please make sure you incorporate it. So I would say that every 5 years is going to be a safe, just revisit. But 7 to 10 years, I think is a good time to just definitely have a second opinion about your trust, make sure it's updated or not.
All right. Now that we know the value, the benefit, the importance, and everything, the nuts and bolts, how much does it cost? I think that's what we get a sticker shock when we go for appointment.
Right.
Yeah.
Right. So it depending on the state you live in, all right, that attorney becomes expensive. And then a lot of times what happened that physician Google the attorney and the top attorney pops up, they call, but by the way, the top attorney at the top fee. I mean, just need to understand. Uh,
Because they pay
so
some fee to Google also.
uh, right. So that's why it's very important that go through referrals. Not necessarily you have to live and use the same attorney. You can use someone like local who are, or let's say, for example, I live in New York, Manhattan, but I actually have an attorney. I'm just giving an example who's New Jersey, but licensed in New York as well, but they are reasonably priced versus Manhattan attorney, right? So that's why it's important to actually get some referrals. So if you're asking how much typically it should cost, a basic will, if you use our attorney or the kind of attorney we work with, is about $800. Just the will I'm talking about. $800 that includes the power of attorney, held proxy, and basic will. If you want to create a revocable trust, since it requires funding, the cost is you have to add on top of that around close to $3,000 more, a revocable trust. It doesn't matter if it's a joint trust or separate trust. So altogether, between $3,000 to $3,500 ballpark, we see the cost for will, trust, power of attorney, held proxy, and revocable trust and funding. That's what we see typical cost.
Okay, sounds good. So, but what about when you update it? How much does it cost each time? Like 5 years, 7 years updates?
Yeah. So if it's like just a trustee change, it's a couple of $100, just a
Okay.
trustee change. But by the way, you have to rewrite the whole thing. It's a brand new trust. Unfortunately, it's another 3,000 due to to 3,500 plus inflation. Whatever in 5 years it is. So we're talking about another 3 grand just to update the trust after 7 years. Everything needs to be rewritten.
Okay. Now let's go to the audience. We have a lot of questions here. First question, Dr. Rajesh Kumar Patel. Is it possible to change irrevocable trust to a revocable trust?
Yeah, so you can basically what happened, you have to dissolve the irrevocable trust. So depending on the irrevocable trust provision. So most, if you have gone to a good attorney, they put something called trust protector provisions there. Trust protector allows to use experts like attorney or trust to actually change the provisions of the irrevocable trust and dismantle it. But again, you need to sign off all the beneficiaries because it's irrevocable. The beneficiary controls everything. As long as they sign off, as long as you have a trust protector clause there, sometime you should be able to change it and dismantle the irrevocable trust.
Okay. And next important question from Neha. For malpractice lawsuit, does having a trust protect your assets? I think that's a very important question for physician perspective.
Yeah, so we'll talk about the asset protection in the next topic, but revocable trust, there's no asset protection.
Mhm.
Remember, all we are doing is a basic state planning just to basically protect probate. Probate means no court, nothing, but lawsuit is, remember, it's under basically your name, not going to court. That's all we are doing. No asset protection and revocable trust.
Yeah, I think the next part of the webinar will be on a little bit on the asset protection, where we will be addressing these questions. Again,
Yeah.
next one, Dr. Srinagesh Palway, one of our board of trustees, asking a question. Once you create a will and trust, do we need to update it every 5? I think you already answered it. Does it
Yeah.
vary by state by state? I think you mentioned if you want to address
Yeah,
it.
and every 5 years revisit it, but usually it's good for 5 years.
Okay, good. And Dr. Usha, how much is substantial net worth means? What do you define as substantial net worth? Can you please
Yeah,
give?
so if I'm just saying it that it's just a rule of thumb, like if you just have one house and then one retirement account, I mean, it is very simple, to get the basic will and trust done. But what I meant by substantial, to us, if your net worth over a million, net worth, I'm talking about over a million, you should definitely get the will and trust done. That's what the rule of thumb as a financial advisor from our perspective.
Very good. And you can, Dr. Ashok, you can create trust which follows the bloodline. So the spouse of your kids don't get the money in case of divorce. Is that a possibility?
Yeah, basically, you're talking about a revocable trust you're creating. So you can do it for the kids' bloodline, but remember, in America, after marriage, unless you have a prenup, everything is equal, like up for grab, right? You cannot just do that. I mean, your spouse deserve, or depending on the state, half of it usually. Most common state property. Divorce is 50-50. I mean, always get divided. But, if you're asking that if you pass away, the money stays in the bloodline of your children, it is possible. That's the way most of the time we create it. The children's spouse doesn't get anything.
Okay. And next question by Dr. Arun Shah. What are the pros and cons of CRT, Charitable Remainders Trust?
Yeah, we will talk about the charitable remainder trust also, for the estate tax purpose. You can do it. Now, charitable remainder trust is if you're charity, just to give you a synopsis, we're not going to talk too detailed. So if you're charity minded, let's say, Dr. Kolli, in your situation, you did decide to give $1 million to AAPI tomorrow. But you don't want to give the million in one shot. You say, is there any way I can get some benefit off of it? Charitable remainder trust, right? So what you can do is rather giving all million, you can create a charitable remainder trust, and $1 million you can put in. Usually you can put 30% of your income, but let's say your income is too high. You put $1 million into charitable. So every year, basically, you can get 5% of the money as an income for yourself. It's called remainder trust, charitable remainder trust, all right? As an income, like an annuity payment to you. You have to pay taxes, but where the income will come from? The income will come from profit. You invest in the market, 5% profit, it goes to you. But after 20 years, I'm talking about all the money goes to, remainder goes to charity. That's called charitable remainder trust. But you have some benefit. You can get some income off of it for yourself as well, your children as well. You can do it in such a way. So that's the benefit of charitable remainder trust. But the problem is that all money belongs to the charity. So if you're not charity minded, don't do this.
Right. So it's not a way to kind of avoid anything, but you
Yeah,
will be losing control of it at some point.
some
But
point. Yeah.
I welcome all the API members to maybe think about putting a charitable reminder trust and make API the beneficiary. Whatever 5% we get, you can take, and rest of it can come to us at the end. Thank
Yeah.
you for the suggestion, Syed. And the next question, I think you mentioned a little bit about Q dot, what it means. I think it's qualified domestic trust. Can you explain what that means a little
Yeah,
bit?
yeah. So what happened, as I mentioned, that husband wife together, U.S. citizen is unlimited, right? They pass away between each other, but that's not the case for non-U.S. citizen, because U.S. government are scared that the non-U.S. citizen will go back to their country and never pay state taxes. So what happened that up to a certain amount, like usually about a couple of 100,000, husband passed away, wife non-U.S. citizen, she inherited, she have to pay taxes. You can avoid that by creating this provision called qualified domestic trust provision. All it does, basically, it says that you're deferring the taxes, but then there's some, rules are there. For example, if the wife become U.S. citizen and the state has not been filing, you can amend it, all of it. But it's in a way to avoid this issue for non-U.S. citizen. Again, detail, speak to your attorney about this. Q dot, it is for non-U.S. citizens only.
Okay. And what about tax returns? What about for the trust? Do you have to have a separate? Because they don't have a tax number, right? It's all under your
No,
number.
revocable trust, there's no separate tax ID. So no tax return. Irrevocable there is.
Irrevocable they have. Okay.
Yeah.
All right. Next, we have a lot of questions. Do we take some more and then go to the next topic? How do we want to do it? Is it true that your primary resident doesn't have to be under the trust?
It doesn't have to be, but we always fund it just to avoid probate.
Okay. And does trust cover assets in India?
No, it doesn't.
You have to have trust there.
Right.
And should a trust be in the name of one individual, that is a spouse, or names of both individuals?
Yeah, so that's something we'll discuss. Asset protection in a perspective, yes, it could be joint, could be separate.
So we keep moving from to different state, like you mentioned earlier. Does the trust transfer with your permanent address to which state laws that govern the taxation?
Yeah, that's why I recommended that once you move to different states, update the statutes there. It's not just automatic. Like, for example, if you're Pennsylvania, you move to Florida, just have the Florida statutes there. Just update that. It's not that expensive.
Right. But for example, if you move, still you have a permanent resident status in a different state.
It should be fine. Those are fine. Yeah.
If we go to an estate attorney to have them form these documents for the will, revocable trust for husband and wife, living will for husband and wife, power of attorney for husband and wife, what is a fair price? I think you mentioned a little bit about it. But one person told me they could do all needed document for 400. Now I have someone estimate 2,000 to 4,000. Can you I think you mentioned a little bit about the pricing.
Right. I think the questions are a lot. Let's just go with the next topic. It's too many questions. We won't be able to finish it. Yeah. Exactly. We can come back if you have time.
Right, exactly. Let's go to the main topics and then question answer.
Yeah.
So let's go to estate taxes now. What is estate tax or a death tax? How does it work?
Yeah, so very quickly, so one husband, wife passed away, both. In America, unfortunately, there's an income tax you pay while you're alive. You have to pay taxes after you die. So that's basically on 24 million. Husband, wife both pass away. You have to, if a net worth is more than 24 million, any net worth more than 24 million, you have to pay around 50% state taxes. But remember, it's 24 million now, but in 2025 is expiring. It's coming back down to around 11 million. So again, this is for high net worth individuals. So as of right now, if your net worth is below 24, nothing to worry about it. But if you're like close to that range, remember the amount is going down. So that's why it's very important if high net worth physician to do some sort of estate planning. But because just to give an idea, if you're single physician, if your net worth right now about 11 million, no state taxes, but after 2025, I'm just talking about it's coming down to only 6 million. So we're talking about 2 million state taxes due for the beneficiaries. So you still have some time right now. Do something to get some sort of state planning done for the state taxes purposes.
Okay. So sometimes pays to be poor, I guess. So all right. How do we select the trustee? That's a personal question, but you can give some ideas on that. I mean, okay, let me go to the topic point. Is there any estate tax rule changes that we may have to worry about?
Yeah, as I mentioned, as of right now, 24 million, no estate taxes, husband, wife both dies, but it's changing it to, is bringing it down is 6 million each. About 12 million is coming down to after 2025.
So in general, these things tend to have even the sunset, but they tend to be extended, don't they? What do you think, Syed?
Yeah, it does. Yeah, but it will be middle ground somewhere. But I don't think it will be staying at 22 million or 24 million. It will come down.
For those who are high net worth, what are the strategies to lower your estate tax?
Yeah, a few things very quickly. Remember, if I start going through too detailed, the webinar will be for each hour for each. So I'm just going to go very quickly, just educational purpose. It will be recorded. Talk to your attorney about it. One option could be do something called SLAT. Irrevocable trust. We spoke about last time revocable trust. Now we're talking about irrevocable trust. So this was high net worth. If you want to gift it right now up to 22 million, you can gift it to the children. The benefit is in irrevocable trust, when you gift it, the exemption goes down. There's it doesn't matter, it's out of your state, and once you gift it, it grows state tax free. On top of it, every year around $16,000 you can gift it. There's no gift tax filing there. So like I have two children, to give you an example, husband and wife together, I can give $32,000 each. Is out of my state. Number three option could be I can buy a second to die life insurance policy. I don't like a life insurance, but for high net worth, second to die life insurance policies are very cheap. It kicks in after both husband and wife pass away. You can definitely do it. move life insurance to an irrevocable trust. Remember, the life insurance, it is part of your state. Once you die, it's income tax free, but it's part of your state. But if you have a huge life insurance, move it to an irrevocable life insurance trust. It's called ILET. Once you move it, the death benefit is out of your state. Extremely very powerful. And the last thing I will very quickly touch base is charitable lead trust or remainder trust. Someone asked the question. This is again, if you're charity minded, what you could do, let's say your net worth is 50 million. I'm just giving an example, and I'm giving a big picture. You, husband, wife, both pass away. You can say up to 22 million go to my children, because there's no state taxes, but the rest of the money can go to a trust, like my foundation I can create. And you can make your children as a trustee of the foundation. They can collect income from there, and then you can make a payment to the charity, and after 20 or 15 payments, the charity goes back to your children estate tax free. Again, I know I went too fast, but the whole idea is there's something called charitable lead trust. Remainder trust is there for high net worth physician whose net worth is 50, 60 million. These options are available to avoid probate and avoid estate taxes.
Okay. I think you answered Dr. Naresh Devan's question about ILATE. What are the benefits? I think
Yes.
that's good. So you also talked about SLAT a little bit. Can you elaborate a little bit on that?
Yeah, so SLAT, as I mentioned, is a spousal lifetime access trust. Just to give you an idea, a lot of people are kind of scared. By the way, if I gift it to my children, what if they kick me out of the house? Because I gifted it, they own it now. One option could be you can create a SLAT, spousal lifetime access trust. In this way, as long as your spouse is alive, she can or he can take the money out and give it to you indirectly. But you can gift it as well. It is out of your state. It's called Spousal Lifetime Access Trust, called SLAT. Now, let me just give you one idea, Dr. Kolli, how powerful the estate tax saving is. This is a real kind of scenario. A client age 60 years old, net worth is 15 million with a $4 million life insurance. And in 10 years, the client wants to retire, but every year, the client is saving around $200,000. So 15 million, $200,000 the client saving 10 years, 7% growth happened, the value becomes 32 million. Current state taxes due, if the law doesn't change, is 7 million. After 2025, if the law changes down to 5 million each, we're talking about 12 million state taxes due for the beneficiary. So one simple tweak, I'll just show you. This 15 million net worth client, I'm hovering my mouse. Through SLAT, you can gift 10 million. Remember, 22 million you can gift it, right? Give $10 million away through SLAT. Your net worth right now for state tax purpose will be counted only 5 million. Still, you can save 200,000 every year. 10 years happen, 7% growth happen, the value becomes 12 million. But remember, up to 24 million right now, there's no state taxes. If the law even changes back down, your state taxes will be due only about 896,000. It's the saving is almost $12 million for the child, for the beneficiary. So again, very powerful. If your net worth is there, use SLAT, give some money away. If you have life insurance, move it to a life insurance trust. Significant amount of estate taxes, you can save it for your children.
Excellent, excellent. All right. What about the cost of making these trusts and to set up this estate taxes and all that?
Yeah, so remember, let me just go back one more time. Will cost $800. That includes health proxy, power of attorney. Revocable trust costs around another $3,000. So altogether about $3,500, it will be done. This is separate on top of it. We are talking about a SLAT and irrevocable trust. So each trust, you need to add $2,500 on top of it. So this one, SLAT, and this one, we're talking about $3,000 ballpark each we're talking about. So usually what happens, high net worth, we recommend go to an attorney and negotiate a good price. Listen, I'm doing so many things with you. Can you just get it done within $10,000 or $12,000? That's what we recommend. But each trust, try to understand, it is around $3,000 extra cost.
Okay. So at least you know what to expect when you go there.
Yeah.
All right, let me go through a little bit of audience questions that they're pouring in there. So,
Yeah.
Dr. Srinagesh, again, if you live one state and will and trust made by an attorney in a different state, do you recommend to update with the same attorney or find an attorney in the state where you're living?
Yeah, as long as the license, the state is the attorney is registered or licensed, is fine. You can just use the same attorney.
Right. If you have beneficiaries on everything, do you need a trust and will? Dr. Alka asked. So beneficiary. Beneficiaries are like life insurance beneficiaries and your retirement beneficiaries. Do you still need a will and trust?
Yes, you do. I think it's a mistake people have it that let's say I have a retirement account, my own retirement SEP IRA, 401k, I have it. I can put my 2-year son in it. But if they call, I have my account, I think with TD Ameritrade or something, or Schwab, sorry, in it. So if they call, Schwab will never release the money. I'm just giving an example. Who are you? Nothing. But you need to have some paper documents to actually shows who that person is. And that basically, that's why you need to have a will and trust as well. The way the funding works, that for the retirement account, primary beneficiary will be the wife. Secondary beneficiary should be the spouse to the trust that you create. So in this way, husband and wife both passed away. The trust, remember, is a private document. The trustee can make a call on your behalf, and the assets could be transferred into the trust the next day. So definitely, you need to, that doesn't matter if you make the beneficiaries.
Okay. Yeah, Dr. Brenda Mehta mentions here that some health systems provide a lawyer yearly plan that will cover trust, power of attorney. Will prep with a lawyer can cover. Okay, it's basically she's suggesting other people to look into their employer to see whether they offer any of these lawyer plans. Okay, you said if both parents die, then the revocable trust becomes irrevocable, right? So
Correct.
how do you change a trustee?
Yeah. So remember the trustee at that time. So when you create a revocable trust, you give the power to the beneficiary to remove the trustee anytime.
Right.
Trustee can be changed anytime. I mean, it happens all the time. The trustee acting weird, they can change it anytime. It's just a beneficiary, and some provisions and divisions cannot be changed.
Okay. Trustees can be changed. The courts can change it, or anybody can change it.
Yeah. So the beneficiary can just request to the attorney, please change it. They can just change it anytime. One piece of paperwork. That's it.
I
Send
think
it to the court, and it's done.
some famous singer went through some issues with changing her trustee and all those, right? Yeah. Anyway, what do you recommend as far as administering the trust is concerned? If your children are not experienced, can you have a brokerage or a bank administer the trust after both spouses pass away?
Yeah, so you can have relatives, but usually if your assets are big enough, we recommend professional trustee. They are fiduciary, like we have a professional trust division, Premier Trust, who take care of it. Brokerage company, if they have the trust division, they can. We have a trust division, we can. But yes, you can actually have a professional trustee. They charge money though. There's no charge to administer, because remember, they kick into play when both pass away, right? So usually we see either a dollar amount or a percentage of the assets to maintain it, depending on, is it like a trust will continue to grow, or you will sell everything and distribute it. They do charge at that time either percentage of assets or a dollar amount.
It's a rough ballpark figure. What is the dollar amount they'll charge? Percentage seems pretty kind of onerous, but
Yeah, so percentage is about 0.5% per year of the whole assets, but dollar amount, like say, depending on the assets. So if the assets are 20 million, they will charge a substantial amount. I would say, assuming 5 to 10 grand, just to distribute it. I'm talking about equally division. But remember, you can make a provisions to the trust to make a dynasty, like it goes on forever. Like you have 5 rental properties, you just want to collect the rent and give it to children, and you want a professional trustee to manage it. Definitely there will be like ongoing keep fees forever to do so. So it does become a little expensive, but if your net worth is high enough to cover it, is fine.
okay. So another question is, can a trust be the beneficiary of any life insurance?
Yes. So remember, if is that's we always recommend the trust should be the beneficiary, not like the children directly. So if you have a life insurance, primary beneficiary should be the spouse, and or you can just make, if it's a joint trust, the trust as a beneficiary, it should be staying in the trust for asset protection for the children, and make sure that the children don't take the money out and buy a Maserati. I mean, you want to avoid all of it, so that's why the beneficiary should be the trust.
Okay, so that's a good answer. So the question for you is, what states do you practice as a financial advisor? Do you have a licensed in different state as a financial advisor, or is it
Yeah,
okay?
I'm a fiduciary financial advisor. If it's question about me, my broker dealer is registered in all 50 states.
Oh, okay, great.
Yeah.
Um, if you have a limited partnership, do you have to put it into the trust?
Yeah. So again, so we're talking about
Not
asset
asset protection, yeah. Should we get into
protection.
asset?
Yes.
Okay. Let's
Yeah.
talk about asset protection. Why is asset protection important to physician? I think this letters, the malpractice and all those things that we already talked about a little bit.
Yeah, so asset protection, I think, is very important. According to AMA, 60% of physicians over the age of 55 get lawsuit at least once in their lifetime. And this statistic is quite higher for certain profession like OBGYN and surgeon, pediatrician is quite higher. Asset protection doesn't have to be that complicated. So I will talk about the first three. I'm hovering my mouse. These are the cheapest one, like less cost of a money. So the state, Dr. Kolli, you live in, Pennsylvania, if you have a joint tenants in entirety, I'm talking about, it's a statute for the state. Like just open an account like a joint tenants in entirety, have a brokerage account, a house and everything. State provides the protection. Maryland, New Jersey, they protect the statute. Very strong asset protection, no cost to it. Another good way to do asset protection is if your spouse is non-physician, like physician usually get a lawsuit, other physician, the spouse is non-physician should not get a lawsuit from malpractice. So just give it to the spouse who's non-physician and buy umbrella policy. So as long as you trust your, other spouse.
You
So
treat your spouse well, you should be okay.
yeah, if you can treat your spouse well, you should be okay. Yeah. So that's another good, easy solution. If you have, uh, you know, a multiple real estate beside the primary house, don't have it under your own name or joint name, have it under LLC. LLC have elements of asset protection. Like if you have 5 properties, 5 different LLC or series LLC, it give you the asset protection that you need. Someone asked about family limited partnership. This is one step up. So family limited partnership give the asset protection that you basically need. Um, but it is not like very strong, but it's decent enough to give you the asset protection. In a family limited partnership, there's a limited partner and there's a general partner. General partner have all the liability, limited partner has no liability. So the person someone asked that how should I fund a limited partnership under the name of the trust. So what will happen? The general partner needs to be an LLC. The limited partner needs to be the revocable trust we are creating. In this way, you avoid the probate. So as long as the money stays in the FLP, family limited partnership, it is fairly protected. It costs another $2,000 to do so, FLP. Then remember 401k, Ash Balance Plan, IRA accounts, it has asset protection elements in it. Make sure every physician have some sort of umbrella policy. Umbrella policy does not cover malpractice, but they do cover if you get hit by a car or some sort of other cases. So umbrella policy, we recommend about 2 million. Most physicians are in the net worth about 2-3 million. Go for 2 million umbrella policy. And then if you are very high net worth, I'm just talking about very, very high net worth and high skill job like cardiologists, you can always talk about Nevada, Delaware, domestic asset protection trust, but these are very expensive. This is not 2-3 thousand. It's about $5,000 to set it up. You need to have a trustee locally, but it's very, very strong protection. Delaware, Nevada give you asset protection. And then remember, if you also gift it to the children through SLAT, it has asset protection as well. So again, I know I went too quickly of a short question you asked, but it just like the idea is give all the ideas and then they can talk to the attorney and choose which one they want.
Okay. You talked about your primary house being protected in some places, right? Or everywhere.
No, it's not. So the big misconception people have it. So the only few states that give you asset protection are Florida, Texas are very powerful. For example, Pennsylvania, there's none unless it's joint tenants in entirety. California up to a certain amount of the equity. So it's a major misconception people have in my assets. Primary house are all protected. It's not true. So you have to do something if all money is in primary house.
Okay. So what are the some strategies for asset protection for physician that you recommend?
Yeah. So that's why I went quickly. So
No.
these are like joint tenants in entirety, asset and the spouse, and these are very low hanging fruits we call it. But if you are very complex net worth we would like to see for Delaware, domestic, Nevada, your net worth is at least 10 million. If it's below that, it's not worth it, all of this headache. So if it's below 10 million, go with FLP and LLC and those stuffs we spoke about.
How much does it cost again for the trust like Nevada and other
Expensive,
aspects?
expensive. Yeah, it is not cheap. It's a $5,000 to 5 to 6,000 to set this up, and yearly maintenance fee about $2,000 to maintain it.
Okay, again, yearly cost.
Yeah.
All right, so let's go through some questions here. Did I understand right? Revocable trust has no asset protection. Dr. Anil Shah, can you answer that?
Yes. So irrevocable trusts have no asset protection. It is only to avoid probate.
Right.
But I'm just giving you one synopsis. Remember, I just go back to the slide. I say more assets under non-spouse name. The trick to it, let's say, I'm just giving example, Dr. Kolli, you are physician, let's say your wife, non-physician. What you can consider doing one trust for you, one trust for your spouse. I'm giving an example, two separate trusts, and give the house I'm just giving you to your wife's trust. So in this way, the assets become segregated. So you can create revocable trust just for segregation, revocable trust segregation purpose if a lawsuit happens. But if she get hit by a car or some harassment lawsuits, revocable trust does not give any protection. So
Okay.
there's none there.
And Dr. Praful Bhatt asked you to discuss naming executor, trustees, power of attorney, family member versus institution. I think it's a personal choice.
Personal choice.
So when you form a revocable trust, do you recommend joint trust or separate trust for the husband and wife?
Yeah.
Dr.
So as I mentioned, yeah. Right. If a spouse is non-physician, is better to segregate it to trust.
What should the 401k balance be at age 45? I don't think that's a question anybody can
Yeah.
answer. What should be, can you place RMD in a CRT without tax implications?
Yeah, so one option could be rather just taking the RMD under your name, it's part of the income, you can just give it to CRT called QCD, through QCD, Qualified Charitable Donation. In this way, the income will not be part of your income. So it's very powerful. Give it to
Okay.
AAPI or give it to CRT, yes.
So then some acronyms are coming up. Dr. Bhavna, what is CLAT, CLAT? What's the difference between CLAT and CRT?
Yeah, so it's a charitable lead annuity trust and charitable retainer remainder annuity trust. Remember, we spoke about. So the difference is remainder goes to charity. CLAD basically goes back to you. That's all I'm going to say for today's. If I get into detail, the webinar will be 2 more hours. So the best thing would be charitable remainders goes back to the charity, the CLAD comes back to you.
Okay, good, good. You already talked about SLAT. Please comment on the role of executor of trust. Who would you, okay, so just as a, again, we answered that. Do you need LLC for rental property? How is
You
it?
do, yes.
That is a
Yeah,
yes.
for rental property, have separate LLC, and the LLC will be owned by the trust you're creating, correct?
Right, right. How is it beneficial compared to an umbrella? Umbrella policy just covers means small.
Non-malpractice, yes.
If your kids are old enough, teenage or older, why not just have a will and have all the beneficiaries listed on the bank accounts and insurance? This seems simpler than a trust. I think this is the common theme. Can you answer
Yeah.
that?
Yeah, so I mean, think logically. So just make them the beneficiary. But if tomorrow the same child, the adults now get married and get divorced, the asset becomes half.
Yeah.
But if you just give it to the trust, remember, becomes irrevocable after you die. The other spouse does not get the assets, and all protect from lawsuits. And plus, they get step-up basis as well. I know that if you want to save money in taxes, you have to learn it. So that's why it's complicated. But the more you keep listening to it, you can get used to it.
Okay. So Dr. Bandaru asked this question. I have two children, grown up, not married. I named my spouse first beneficiary after her. Each grown-up child gets 50%. Nothing changes. Is there a problem with this approach? There are grown-up children. Again, the same thing, right?
Same
They
thing,
get
correct,
divorced. They're not
correct.
married. One day they
Yes,
might be married and they
yep,
get lawsuits.
yep.
Can we put irrevocable trust as a trustee on revocable trust?
Irrevocable trustee into a revocable trust. You can have that, but it's like, why make it all this too complicated? You can make anything as a trustee, but then irrevocable trust as a trustee is like, over, does not make any sense to me. The best thing would be have a professional trustee, and that's it. Does not
Okay.
make any much of a sense.
Yeah, probably it might save money. Probably that's what it is.
Yeah.
Okay. Any benefit of creating LLP or a trust?
Yes, there is LLP, as I said, limited liability. LLP, we're talking about similar to LLC, similar to FLP. It does give the asset protection that you need. If that's what the person is, suggesting, yes, there's benefit of elements of asset protection. But the member of the LLP, the FLP needs to be the revocable trust to avoid the probate.
Okay. Next question, Dr. Ashok. If your account has POD or TOD provision, doesn't this override the trust?
Yeah, so if you have the POD or TOD in a bank account, so POD means, after death, TOD, transfer on death. What it means, so it is under your name, you just have to change the TOD or POD to the trust. That's it. Yes, it's overridden. So you have to just change it under the name of the trust. That's why, as I mentioned, funding is very important. If you don't move all of this stuff, you will still go through all the headaches after you pass away.
IRAs, Roth and non-Roth funds included in estate tax calculation?
Yes, it does. Everything you die, pass away, all the assets, including life insurance proceed, will be part of your states for calculation.
All your assets, including your art collection, your car.
Art collections, your car, your jewelries, correct.
Can beneficiaries be trustees?
Yes, you can basically, so what happened that we make the beneficiary to serve as a trustee after a certain age. We do it typically. After, like, the spouse passed away, or sometimes you can just say, usually we always put the spouse as a beneficiary, as a primary trustee. But what happened that if the secondary trustee, we put beneficiary after a certain age could be the trustee. Correct. Absolutely. We do it all the time.
All right. This is more of a tax question. Is permanent life insurance tax-free for kids?
Yeah, income tax free, but to the children. But remember that benefit is part of the state. If the state is altogether life insurance, everything more than 24 million, yes, estate tax is due.
Okay, Dr. Anjan Chowdhury, donor-assisted charitable fund. How does that work?
Yeah, so donor advised fund. Remember, charitable remainder trust, charitable lead trust foundation is cost to set this up, right? It's about 3,000 to 4,000. One option could be you can do a donor fund, like with Schwab, Fidelity, TD Ameritrade. You can just open up a donor fund and just transfer the money there. And from there, you can write a check. So it's very simpler, less flexibility, but it's very cheap. Yes.
Yeah, you can even transfer your stocks and all that. So
yes.
You can avoid the capital gains.
Absolutely.
Is IRA protect against malpractice?
Yes, up to a certain amount, close to about not 100 unlimited, like 401k defined benefit have unlimited ERISA protection, but not like 100% IRAs. IRA, certain dollar amount we have to check, but about 1 million, it has asset protection.
Okay, there are two questions. Dr. Satish Katula, Vice President of AAPI, asked a question. I was told that life insurance is protected automatically. Is there a need to put it in a revocable trust?
Life insurance is protected automatically. No. So the reason why you put life insurance under a irrevocable trust for the death benefit to be out of your state. That's the reason, not for asset protection purpose. So you just move it. So let's say your net worth, your life insurance is 10 million. Remember, if your net worth is, let's say 15 million, 10 plus 15, 25, boom, you go over 22 million. But if you have 10 million life insurance death benefit, move it to a life insurance trust that benefit is out of your state.
So to avoid the death tax, you can
death tax, yes.
Okay, another question about Indian property. Any properties we own in India, can they also be put in the trust in the USA, or is it valid legally both here and US and India? Dr.
Yeah.
Ravi?
Yeah, remember that the Indian, you have to have Indian will and trust. It doesn't work here. But remember, up to 22 million, regardless, wherever you is inheriting it from, doesn't matter. There's no state taxes.
Right. as far as taxes and laws in India, probably you're not the right person to
Yeah.
answer. If both you and the spouse are physicians and the hospital employed, which option would you be good for asset protection? I guess, yeah, go ahead.
Right. I mean, it's a little bit, it's a very generic question. I need to ask some more, depending on the other assets. But yes, I mean, depending on husband, wife together, so joint trust, but no asset protection, FLP, Nevada, SLAT, a lot of things come into play.
Okay. Dr. Ravindra Kota, what about foreign asset protection? Are they useful or necessary? For example,
Yes. So offshore asset protection trust is not really necessary. I mean, you can, like, people go for Bahamas and stuff, asset protection trust, but it's not needed. You have Nevada, you have Delaware, go for that. Why offshore?
okay.
Yeah.
All right. I guess they're not able to hear me very well. Are rules for asset protection same as S corporation like LLC?
No. So, well, it has the element S Corp and LLC. Remember, if you, this is for your, so LLC you create for rental property, right? So whatever owned by that LLC are basically asset protected. But then S Corporation, you actually doing some sort of business and you have some income in it, you're self-employed. So it does give asset protection for the business you are doing into it. But what we are saying that, the asset protection, let's say the statutes differ. Like, for example, the asset protection for Nevada, Delaware are much stronger than just an LLC asset protection. We just need to understand. As long as we know that there's a level of asset protections are there, but physicians should not be scared about listening to the attorney and go with the most expensive one. Life is, Dr. Kohli, we have to take some risk. There's nothing called risk-free life. If you want to live still like you have to stay in a bubble, right? So that doesn't mean that you keep spending the money and doing all this fancy stuff. So that's why speak to the attorney and financial advisor, see what risk you feel comfortable, and do some layers, few different stuff. So within a reasonable cost, you can get it done.
Okay, the problem is a common sense question. If you already have a malpractice lawsuit already, is it too late to do asset protection?
Yeah, if it's already, remember this already pending, but the state statute said nothing much can be done. I mean, it's already going, but still I would do whatever I could. The lawyer would most likely will say the lawyer is the right person to answer it, but if it's already going, I would speak to the attorney and say, does it help or not? But
Okay.
ideally, you should do it before obviously all of this happened.
Yeah, it's like going to a doctor after you had a heart
Yeah,
attack. Yes, you're still
correct.
going there.
Yeah.
Uh, any comment on LIRP life insurance?
Yeah, you can do the LIRP, life insurance trust, tax-free we are talking about, but it's a permanent policy. Remember, the way LIRP is called life insurance retirement. That's the philosophy they have it, but I'm not a big fan of it. Like the way they are talking about that you have the life insurance, that you actually have the cash value, take a loan against the cash value, tax free. It sounds too good to be true. It hasn't worked out that well. So my suggestion is rather doing that, go with like some stocks, mutual fund, bonds, investments.
Okay, what about, is it good to have an executor as well as a co-executor?
Yeah, you can have both if you are concerned about. The more you have, the better control you have it.
Okay. Is step up in stocks changing? I don't know what it means. If step
Yeah.
up in,
So remember, the revocable trust, one of the benefit is that one both pass away. If you buy stock for $100 Apple, you pass away, and the stock right now 150. The children inherited 150, step up in cost basis. Biden administration was kind of vocal about changing it,
hmm,
but as of right now, it's out of the window.
okay. Um, if you have defined benefit plan and your retirement's fund in it, can lawsuit protect from going after your retirement funds?
Yeah, remember defined benefit 401k unlimited. That's what the law is, Arisa. So
Yeah.
that's why even it's a tax deferred purpose, physician do the defined benefit of 401k is lot. Yeah, it's very, very strong protection.
I don't know. The question, Dr. Sangeeta Palasa, it's probably you won't be able to answer this. Children born can inherit properties in India? I guess she meant children born in USA. Can they inherit properties in India?
Yeah, they have to go to India. I mean, yeah,
They want to
to
have the
release it.
property.
Yeah,
Some people don't want to have any properties there.
right.
Okay. Umbrella coverage 1 to 2 million, which is with such high coverage, does it not make it more likely to be sued even for small accidents? You get sued
Um,
whether you have it or not.
yeah, I mean, it doesn't really matter. Right.
Right. Because they are coming after your other assets, not your insurance
Correct.
coverage.
Correct.
Yeah. Um, it's a long question here. Let me read it you can answer it. If I have my bank accounts and brokerage accounts titled as tenants in entirety right now, is it better still to move these to the revocable trust? Or is it better from asset protection to leave it that way right now, since you said the tenants of entirety gives some asset protection and the revocable trust does not give asset protection?
Yeah, so that's why I said it's the balance we have to take. So you want to avoid probate, but you want to avoid lawsuit too, right? So remember, joint tenants entirety doesn't. So if it's like few properties, um, I would try to do like a TOD or POD. It's not going to be owned by the revocable trust. So yes, so that's the comfort zone. We have to see what you feel comfortable. Maybe have, some have, just keep it under revocable trust. That's usually what we see, like especially in state like Pennsylvania, we see it all the time. Attorney said, you know what? I know it will go through the probate, but you have a joint tenants in entirety, which is very powerful for asset protection. Maybe like, the physician become retires, then move it to the trust because you retired, you get the umbrella policy. Why do you have to worry about? So it is a discussion needs to happen. I cannot give a straight blank answer right now. More discussion needs to happen, but it's a balance needs to be done.
Yeah, almost we went over an hour. Okay, last question will go. I think this is a pretty simple thing to answer. Can you open a defined benefit plan and have a 401k plan in the same year if you have both W-2 and 1099 income? I would say
Yeah,
yes.
yes, for the 1099 portion, correct.
Mhm. Okay. I think there are some accolades for you for doing a great job again. And thank you. And there are a couple of more questions, but we'll skip those. And thank you again. Do you want to say anything, concluding remarks and any contact information? And I want to thank all my audience, 200 of them plus, coming here again on a Wednesday evening to support API and as well as learn something about asset protection, wills and trusts and everything. Thank you. And
Thank
go
you
ahead.
very much, Dr. Kohli. Yeah, so I don't have all. I'm just going to say that you know what, the state planning could be complicated, but the best thing would be if you subscribe to some website like White Coat or go to Kevin MD, this website. Don't get overwhelmed by the estate planning. As long as my suggestion, first step it is just get the basic will and trust done. That's it. As long as someone can get it done for $3,500, the rest of it, slowly do it. Don't get scared tactics like I see some people come in and just say, do this, do this. Now someone will grabbing your assets. Don't worry too much. Slowly do it. But most important thing is to organize yourself. That's what the whole purpose of doing the estate planning, and that's it. And a fiduciary financial advisor should be able to help you in your local area. See who's the fiduciary advisor who can help you with it.
All right. I think we'll come to an end here now. Let me see. We have a couple of hands raised, but I think probably they're left. Anyway, thank you again, Syed, and really appreciate your support. And it's always an educational experience whenever you come and talk to us. I know these are very complicated subjects. We cannot learn all of it in 45 minutes, 1 hour session. There are probably some books and website are there, but at least you whet the curiosity for us to go and learn more and do the basic things like getting the wills and trusts and find a lawyer. And Syed can give you some referrals. You can contact him. I really appreciate all the audience for being here so late. Again, thank you and have a wonderful holiday season and be safe during. Again, there is some surges in infections coming along. So please watch and especially if you're visiting elderly family members, be careful. And again, thank you and see you all soon again, maybe next year.
Take
Thank
care.
you.
The recording will be available for everyone. Thank you.
Thank you. Thank you. Good
Bye
night,
bye.
everyone.
Good
Bye.
night. Bye bye.
We'll sign off here now. Thank you again. Bye.
Thank you. Bye bye.